Disclaimer. Judge Ron Rangel is providing this podcast and website for educational purposes only, as well as to give the public general information regarding topics related to the criminal justice system. The views, thoughts, and opinions of his guest speakers are the speaker's own and do not represent the views, thoughts, and opinions of Judge Rangel. All rise. You are now listening to Beyond the Gavel with Judge Ron Rangel, educating the public and expanding mindsets. Subscribe on our website, beyondthegavelpodcast.com, or your favorite podcast platform for more of the latest podcast episodes and updates.
Welcome to Beyond the Gavel with Judge Ron Rangel. I'm your host. Thank you so much for joining us today. You know, we had a little bit of a hiatus, maybe a week or two longer than typical. The reasons for that vary, but really, we've been absolutely swamped in the 379th Criminal District Court here in Bexar County, Texas. And Alana, who is absolutely responsible for everything we do, is in her first semester of law school. Very proud of you, Alana. And she's been busy as well. So anyway, thank you for sticking with us. We got a really good episode today. In the studio, we have Lauren Lefton.
Hi, Judge. How are you today?
I'm doing great. Thank you for joining us. Now, Lauren grew up in San Antonio, Texas, and attended the University of Texas at Austin. At the end of her senior year, she decided to go to law school, ended up in Cleveland, Ohio at Case Western Reserve University. It took her one cold winter to recognize that it was vital for her to return to San Antonio and to Texas after law school. Now, when she graduated from Case Western, she worked as an assistant county attorney in Guadalupe County. That's a neighboring county to Bexar, for those of you that are not from San Antonio. As a prosecutor, she handled criminal cases, juvenile proceedings, and some CPS matters. I did the same thing, by the way, when I was a prosecutor. After 4 years as a prosecutor, she started her own defense practice exclusively focusing on criminal law. Almost 5 years ago, she was appointed by the San Antonio City Council as a part-time municipal judge there, where her primary duties are related to magistration. Now, magistration and bail setting and bonds is a really hot topic in San Antonio nowadays.
It is. It's been in the news.
And from your perspective and from what you understand, why has that been an issue in San Antonio?
Well, I think what's been coming up lately has been officer safety and public safety, where there are people maybe with criminal histories or are currently out on bond that are accused of committing new offenses.
Part of your role as a magistrate then is to do what?
So my duties as a magistrate, and people are magistrated because they have been recently arrested, either for a warrant or what's called a warrantless arrest. And so it is my job to inform them of their charges, that they understand their rights, and in some cases evaluate for the possibility of a bail.
All right, so the Constitution of the United States requires that upon arrest, an individual must be taken without undue delay before a judge. And part of that process means that they go before a judge who will then explain to them their rights and then set bail after identifying that they're the individual that is accused of a crime. The Supreme Court of the United States under Sandra Day O'Connor ruled that without undue delay means within a 48-hour period, which is not a problem in Bexar County. Is that right?
That is correct. Bexar County is a 24-hour operation.
And I think probably more so in urban areas because of the resources, right?
And I also think the volume. So if the county did not continue to magistrate people from Friday at 5 p.m. to Monday morning at 8 a.m., it would be such a backlog that people's rights would be violated. They would not meet the 48-hour requirement.
So before we get into that, let's talk a little bit about what else it is that you do, right? You're a criminal defense attorney.
I am a criminal defense attorney, solo practitioner.
What's that life like for you?
I really enjoy it because I get to practice in Bexar County, along with many other counties in Texas. And you get to really see all facets of the criminal justice system, meaning that you get to interact with all the different judges. You take on a variety of cases. I personally do traffic tickets all the way to felonies, which is a unique approach. Typically, you see lawyers doing all misdemeanor and felony cases or just traffic tickets.
And traffic tickets is different, right? Because you're dealing not only with, let's say, justices of the peace who are elected by individuals within a certain county, but you're also dealing with city municipal type courts.
Correct. I do it in rural counties, which is always interesting because in rural counties, most justices of the peace are non-lawyers. And even some municipal judges are non-lawyers. And so as an attorney, it's always interesting practicing in front of non-lawyers and navigating the issue of a JP judge's personal beliefs versus what the law is.
And that's interesting because in the law, a county court at law that handles misdemeanor offenses or civil cases within the county court at law system, all district courts, which is a felony type court and also handles higher level jurisdiction for civil cases, appellate courts, in every one of those courts, an individual is required to be a practicing attorney first.
Correct.
But for justices of the peace in Texas, the only requirements are 18 years of age, not have a prior felony conviction, and reside within the jurisdiction for a certain period of time.
That is correct. And it was pointed out to me because there is a movement right now to require justices of the peace to be attorneys because they are handling small claims cases of up to $20,000. But one of the rural justices of the peace pointed out to me that that will never happen in Texas. They will never require a JP judge to be an attorney because the truth is there's so many rural counties in our state that don't have a lawyer that is a resident of that county. And so it literally would be impossible to fill the position if you required a lawyer to be in the position in some location.
What is it like for you to go before that type of a jurisdiction?
I've really found that if you're always respectful of the judge and the court system, that even if they're not interested in what you have to say, they're willing to listen and talk to you.
Mm-hmm.
And so that really has been the key to my success in doing the traffic tickets and justice of the peace citations in rural counties. If you're polite and considerate, they're willing to listen to you. And usually it results in some success.
You're also a practicing criminal defense attorney, is that right?
Yes, sir.
Now, I note that because when you came in, I asked you, you appear to be dressed like you're in trial. Are you in trial right now?
I am in trial right now in the 227th District Court here in Bexar County.
What kind of case are y'all trying?
It is an injury to a child case.
Which is a third-degree felony?
Yes.
All right, so let's talk about what happens when somebody gets arrested. Somebody gets arrested, they're taken before a magistrate. You work with the city. Now, you were appointed in your position, correct?
That is correct.
And so I am a criminal district court. On the county side, we also appoint magistrates, but you were not one of those magistrates.
That is correct. I'm titled a city judge that primarily works as a magistrate.
Which makes sense. So there is no work connection related to the magistration process or the court process between the two of us, right?
That is correct.
All right. So understanding that, what happens when somebody is brought to you?
So when someone's brought to me, before I even see them, I do review the police report. I determine if there was probable cause for arrest. If there are any extra warnings, such as if the person's not a citizen of the United States, there are specific what they call them consular notifications, but you would need to see if that's going to be an issue or something you need to address. After I review the police report, I have a choice. If there's no probable cause, I can reject the case, meaning that I did not think there was enough information there for a legal or appropriate arrest. If I find there's probable cause, that's when I would then go and magistrate the arrested person. And it's very important at that point, I think, to speak with them so that they understand their rights. But not only their rights, they have to know what the process is. Because I think the best thing to do when you're magistrating someone is assume they have never been arrested before. So for them, it's a very confusing, scary moment. You literally have lost your freedom. I know it's temporary in that most likely there is going to be a bond set and the person will bond out, but it doesn't feel that way to that person.
Now, in Bexar County, there are 23 municipalities that work within the county. Well, you think of the city of San Antonio, then you think of all the other types of cities. Just to throw out a couple, you have like the city of Balcones Heights, city of Helotes, you have Converse, Universal City, Alamo Heights, Terrell Hills. All of those individual municipalities have their own police agency.
Correct.
So those other agencies, other than San Antonio city police officers take their individuals that they arrest directly to the county. Is that right?
That is right. They do that.
So you're dealing specifically only with individuals that are arrested by San Antonio Police Department.
San Antonio Police Department, and sometimes we see DPS trooper cases.
Okay. So then they come in, they bring them to you. Let's sort of paint a picture for those that are listening as to what it's like within the jail. So you're actually in the city detention center.
I am in the city detention center, which is part of the municipal court building.
What's that like?
So the detention center is divided into two sections, essentially the area where the arrested people are, and they're in their cells with the detention staff observing and monitoring the arrested people. There's a nurse's station there, and then there is a intoxilizer room where if people are arrested for DWIs, they have the option to do a breath test.
All right. So let's say the San Antonio Police Department arrests somebody for robbery. Let's say a second-degree felony, shoplifter, somebody is grabbing something from Walmart, and as they're exiting, the manager or some person within the store tries to stop them. They get pushed aside, charged with a robbery.
Okay.
All right. Theft by force. How long does it take from the time that the police then meet up with those people, arrest them, and then take them to you over at the city facility?
It could take an hour probably between the police arriving at the scene and then the person arriving at the city magistrate building. Then what happens is a criminal history run, and the officer then generates or write his report. So that does vary depending on how long the officer wants to spend writing his report. Sometimes it can be done very quickly. Other times, if it's a more complicated report, it can be longer. The DA then reviews the police report and signs off on the information, and then the file and report is submitted to me. At that point, I review the report, make my determination of probable cause, and try to then see the person as soon as possible for them to be magistrated.
So you talk about criminal histories being run, and I'm assuming that's the NCIC TCIC, correct?
That is correct.
All right. And so with the NCIC TCIC is it's a database. NCIC is a national database that includes people's criminal histories. The TCIC is a Texas-related criminal history background report. NC, the national one, is put together by the FBI. The TCIC is put together by the Department of Public Safety. But now, as of April of last year, 2022, there's something called a PSRS. Is that right?
That is correct.
What is that?
It's a new requirement under law that in setting bail for arrested people, this report system needs to be utilized and used to evaluate the appropriate bail amounts. Now, in the city of San Antonio, we have made the decision, rather than setting bail, we are just finding probable cause and then committing the arrested person over to the county, and then the county magistrates, they use the reporting system to then make their determination in bail setting.
So then with the city, because y'all are basically finding probable cause and signing other issues related to arrest, like warrants, let's say there needs to be a blood draw, you're actually not setting bail. So you don't use within the city of San Antonio the public safety reporting system. All right. And that's because you're not setting bail.
Correct.
So then somebody comes in, you want to make sure that it's that person. Let's sort of explain to the listener how this exactly works. Let's say that you're at your shift, right? And you work part-time, right?
I do work part-time.
And that's so you can have your own practice.
Right.
All right. So you're working part-time, it's your shift, you're sitting there. The police then, maybe an hour after an arrest, brings an arrested person before you.
No, it actually doesn't work that way. So what happens is we do dockets of 5 typically. And so I hold court and see about 5 people at a time. And we do have a courtroom. So the detention officers bring in the arrested people and I magistrate each person individually, but in groups of 5.
So you ask them, is your name blank?
Yes, I say, is this your name? And then I inform them of what their charge is and what level of offense it is. You only magistrate people of Class B misdemeanors and higher. So if you're just arrested for something like public intoxication or a low-level theft, like under $100, you may be at the city jail. However, you do not have to have a bond to leave the city jail, and you do not need to be magistrated because it is a fine-only offense.
So those folks then would be arrested. They would stay at the city facility until whatever time has passed, and it's deemed that they could then be released.
Exactly, on their own recognizance.
So if it's somebody, let's say, charged with a public intoxication,
Yes.
and they come in, they're clearly intoxicated. The police brought them in for their own safety.
Right, and the public's.
Yes. And then what happens then?
They get to hang out in a cell until they blow under a certain level, which the nurses deem is safe for them to then be released, and they can return for their court date. Typically, it's about 8 hours.
What happens if that individual refuses to blow into a machine?
Then they have a set time they have to stay there so that the nurses can be assured that they reached a certain level of sobriety before they can go.
And then those are for the Class Cs.
Those are for the Class C.
In the law, a Class B misdemeanor is the lowest level that somebody could actually go to jail for. The range of punishment for that is up to 6 months in jail and or fined from $0 up to $2,000.
Exactly.
So for those kind of cases, and generally speaking, those kind of cases, you have like low-level thefts, you have possession of marijuana under 2 ounces. What are some other Class B misdemeanors?
DWI, of course, is a common one. If it's a first offense, you would have a DWI as a Class B misdemeanor. Criminal mischief can be a Class B misdemeanor depending on the value of the damages alleged. And criminal trespass is another hot topic Class B misdemeanor that you see people arrested for typically.
What is the general waiting time or waiting period that an individual who's been arrested has to wait before they go and see you?
Realistically, between 4 and 6 hours.
All right, so then somebody is arrested, 4 to 6 hours later, they come before you. You have that discussion with them related to making sure that they're the person that's arrested.
Yes.
You read them their rights.
I do.
How does that work?
I make sure they understand the right remain silent, and I also explain to them what that right means. It means they do not have to speak with the police, they do not have to make any statements to me, and that anything they say could be used against them. Because we all know what our rights are thanks to TV, but I don't think people truly understand them.
Does an arrested person have a right to have a lawyer at magistration?
No, they do not. However, there has been a lot of proactive movements for attorneys to be there. So I know at the county magistrate center, there is the public defender's office there, and they do represent people in the hearings over at the county. Because I'm not setting bail, I'm only making a probable cause determination. It's not as necessary, I think, for an arrested person to have an advocate there for them.
Because more than anything, the reason why you would think it would be helpful to have an attorney at magistration is for an attorney to interview a client and then to tell the judge, my client has lived here for this long. My client makes this amount of money. My client spends this kind of money. My client is or isn't indigent based on whatever factors exist.
Correct. Exactly.
And then there's also issues related to the safety of the community and the safety of themselves.
Which is very important.
That makes sense.
Yes.
And so the issue of having representation and magistration is something that occurred during my administrative administration here. And so we have an agreement with the public defender's office for them to provide representation at magistration. Now, the issue with that is you also have to have a prosecutor there.
That is true.
Otherwise, it would be an ex parte conversation, meaning it would be one-sided. Judges can never hear from one side of a lawsuit or a criminal case without the other attorney on the other side being present. So at magistration, you don't necessarily have that issue because you're not requiring information from the defendant other than you are the arrested person who we are naming in this complaint.
Exactly.
I'm enjoying this conversation with Lauren Lefton. Let's take a short break.
This is Q&A with Judge Ron Rangel. Submit your question today at beyondthegavelpodcast.com.
Time for Q&A. We got a great question. Have you ever declared a mistrial? The answer is yes. Now, as a district court judge, we do handle felony trial cases. The most common type of mistrial is one wherein a jury has been in the jury room, they've received all the evidence, I've instructed them to begin their deliberations. They're deliberating. After so long, they'll send me a note and say, we've been deliberating, we cannot come to an agreement. In the law, if somebody is going to be found guilty or not guilty, it has to be a unanimous jury. In other words, in a criminal district court, all 12 jurors have to agree to whatever the ultimate verdict is. If a jury comes back and says we cannot agree, And if I believe enough time has passed, and I've already advised them through something called an Allen charge, that although you've heard the questions involved, although you've analyzed this case, if you do not come to unanimous agreement, a future jury is going to have the same issue because they're going to have the same evidence to consider. Please continue to deliberate. If that jury persists and tells me that they're unable to come to a unanimous verdict, then I can declare a mistrial. What that means is the whole case has to be tried all over again. There have also been circumstances where a jury has come back with a verdict on guilt innocence and say, we believe that the defendant is guilty of this charge. However, during the punishment portion of the case, they're unable to determine what the appropriate punishment is. Theoretically, a mistrial could be declared for punishment purposes only. Mistrials could be called for other reasons. Recently, we've had an interesting situation. After I swear a jury in, I tell them, you're not able to talk about this case with anybody, including each other, until I've formally given the case over to you to begin your deliberations. We found out that a jury during breaks was in the jury room talking about the evidence, talking about how they didn't believe certain witnesses were testifying, how they didn't believe certain aspects of the evidence. As a result of that, I called them in. We brought in some witnesses who were on the jury, found that that was true, and I declared a mistrial. Lauren, do you have any thoughts about this?
I think a mistrial is always very exciting because it's kind of the ultimate ending, but is interesting.
Excellent question. Thank you so much for that. We enjoyed answering that question. Please keep them coming. Let's get back to the show.
This is Q&A with Judge Ron Rangel. Submit your question today at beyondthegavelpodcast.com.
Welcome back. I'm talking with Lauren Lefton about magistrations. We talked about someone being indigent. What does that mean as it relates to magistration when you say an individual falls under that category?
What that means is that after speaking with them, or in the case of if they're at the county, their public defender has interviewed them and information is presented to the court what their monthly income is, that if they can or cannot have the ability to pay for an attorney for representation.
So in the magistration sense, indigency means you don't have the means to hire an attorney.
Correct.
And because of the Sixth Amendment and the way that's been defined by courts, everybody who's charged with a crime where they can end up in jail, Class B misdemeanor or up, has a right to have an attorney represent them.
Exactly, because the founding value of our country is our liberty. So if your liberty is at stake, it is very necessary to have an attorney advocate for you, I believe.
So you talked about officers writing reports. How long does it take an officer to write a report that is sufficient enough for you to look at and say there is probable cause in this case?
I've seen 6-sentence reports, but it meets the elements of the offense. So you're looking for, did it happen in Bexar County? Did the act that is required for the charge occur? And is it the person named in the report that is in front of me? So it can be as basic as that.
So it's the who, what, when, where, and how.
Yes. We don't care about why.
That's right, because that's a motive, right?
Right.
And motive is not something that is required to prove in court. The idea is who committed what action to where, was it in the local jurisdiction, et cetera.
Right.
So a lot of times an individual is arrested at the scene, but there's more investigation to be done.
Right, or there needs to be. That is correct.
So you have, let's say, an arrest is made, a reporting officer then goes to the scene, takes an individual before you so that they can be magistrated, probable cause can be examined. But let's say if it's a higher level case, you still have detectives maybe that need to get out there.
Right, because even the police are a 24-hour operation. They have a certain hierarchy and order of things. So if a night detective may be called to the scene to deal with it at that moment, but then they'll really refer the follow-up or the extra investigation to the daytime detective. And so that information is never available to any magistrate at that time because it's work that's to be done in the future.
So there's the magistration process then exists with the county, where once they see you, then folks that are arrested by the city of San Antonio or some Texas Department of Public Safety officers will then take those particular arrestees over to the county. Then different sort of process takes place related to somebody's bail.
Correct. Yes.
And so let's talk a little bit about bail. Back in 2015, myself and other district judges signed a joint order regarding the setting of bail, we had what is referred to as a bail schedule. Are you familiar with that?
I am, yes.
Do you want to sort of explain what a bail schedule is?
A bail schedule, I would say, was guidance from the district court judges of what collectively they felt was the appropriate bond amount for certain type of offenses and certain level of offenses. It wasn't a requirement to follow it, but it was a guideline that typically for a third-degree felony drug case, we like a $5,000 bond. Or for a Class B misdemeanor, we like $1,000 bond. And, throughout allowed the magistrate to have some guidelines and really a general standard that people could expect.
Sort of like a starting point.
Yes.
Because the way the law works and the way ethics works within the judiciary, judges can never influence other judges in terms of how they see a case.
Yes, that's a very important point, and it's very interesting to see that play out, what judicial independence is. But that is a special part of being a judge, is that you answer to nobody. It truly is your own approach, perspective, and in a sense, your moral code or compass of what you think is appropriate and fair.
So because you're a city judge, you get appointed to your position by members of the San Antonio City Council.
Yeah.
And then the county judges or magistrates are appointed by the district court judges, but the district court judges cannot tell a magistrate what the appropriate bond is on any case that they're looking at.
Right.
Magistrates then with the county look at a case and they determine what is fair. But the bond schedules is sort of a guide as to a starting point, right? And once they establish that starting point, then it's up to them to figure out the individual circumstances that exist with the case before them and figure out what is fair.
Right.
The bond schedule that we had signed, the last one that we had signed in 2015, lists, for instance, cases like 3G offenses, think of murder, aggravated robbery, aggravated sexual assault, those kinds of cases, what we consider to be the aggravated cases. Bail should have sort of a starting point of $75,000.
Mm-hmm.
The idea then is, in the law, because a lot of folks want to know, what is it about bail and why do certain people get bail or have the opportunity to bond out through bail when they get arrested?
Well, it is a constitutional right. So fundamentally, most everyone is entitled to a bail. Now, what I find very interesting about it, and there's been a lot of movement and progression towards a more equal bond setting system, is that in our country, we really tie it to affordability. So you can be charged with murder, but if you can afford a $500,000 bond, we have as a society said, you're safe to be out of jail. You don't have to be in custody. Now, we are seeing or feeling maybe that isn't accurate, that maybe there should be other things taken into consideration. And there is a process as of April of 2022, I believe, that allows for someone to be held without bail if certain requirements are met. But there's also a push to move to a non-cash-based bail system, because for someone, a $75,000 bond may as well be $1 million bond for certain or parts of the population. I have found very interesting, just observing as a defense attorney, is the movement towards more personal recognizance bonds, which is being released without making a payment, or very low bonds, is I don't think we're seeing the return of people appearing in court. Because really that's the purpose of a bond or a bail, is saying we don't need you to sit in jail. The public is safe enough until your court date, but we want you to have some skin in the game to make sure you come back to court. And I don't think we've found a solution that isn't tied to financial stakes to make people appear.
Well, let's talk a little bit about that. You bring up some really good points. So the first thing is bail is considered to be an Eighth Amendment constitutional issue. In other words, the Constitution of the United States says that when somebody is arrested, bail should not be considered to be oppressive. Right. Somebody is charged with a crime. Legally, according to the Constitution, they have a right to come out of jail or out of custody while their case is pending. Bail is the amount of security that is required, set by a judge, to make sure that somebody goes to court.
Right.
A bond, on the other hand, is the actual contract that is made between a surety, an individual who is promising that arrested person is going to show up in court, with the defendant.
Yeah.
Understanding that up until last year, bail could never be denied at magistration. The only time that legally I was able to remove somebody's bail is when they're accused of a capital case looking at the death penalty, and I, as the judge, would make a finding that I believe there's proof evident that a jury is going to listen to this evidence, is going to find somebody guilty of a capital case, and will subsequently sentence somebody to death.
So a pretty significant standard.
Beyond that, everybody else would have a right to bail.
Right.
Now, the law is starting to shift a little bit, but we're talking about cash bail, and that's a great point that you make. The other alternative to cash bail that is talked about is something called risk-based assessments, right?
Mm-hmm. Right. And I think of it as pretrial in Bexar County, the pretrial services department performs it.
Now, the issue with risk-based assessments, some would argue, is that they're actually discriminatory in nature. So what they do is they analyze whether or not somebody gets points for being a danger to society based on a demographic. For instance, if someone lives alone, they are considered to be at higher risk to society of getting a bond than somebody who lives with another person.
Correct. Also, if you are a male, you're considered to be a higher risk to society than a female.
Age is considered. A younger person is considered to be more of a risk to society. Whether or not somebody is employed or not has an effect on that risk-based system. Whether or not somebody has ever failed to appear in the past, regardless of how long it was. They're considered to be not necessarily accurate, but that is one of the other alternatives that's been thrown around, and it's not without its issues.
Exactly.
So what's the answer?
That is, I would say, the $1 million bail bond question.
That's a difficult question.
That is a difficult question.
Kind of the way bail reform has gone in the last couple of years, the idea that somebody who's charged with a non-violent crime should not necessarily be in custody while their case is pending. That makes sense to most people.
It does, yes.
And violent people that are charged with violent offenses, somebody who's charged with a repeat violent offense, then generally speaking, would have a much higher bail amount that's set.
Right. And as of April of 22, our legislature made it even more difficult for that repeat offender, especially if they're already on bond for a felony, to get a reasonable bail set, because the court that the original felony was out of, that judge needs to review the new case and be a part of that bond decision as well.
We talked about the PSRS system and how that is now a requirement for magistrates to look at when they set bail. As of April of last year, 2022, folks that are charged with a violent offense are not legally capable of getting a PR bond.
That is correct. And if you have any assaultive history, no matter how old, you are also not eligible for a PR bond anymore.
So I think that's kind of a misnomer. I think there's a narrative out there that says that violent repeat offenders are getting out on PR bonds.
Right. That is definitely not happening at Bexar County.
It doesn't happen at magistration.
Definitely not at magistration.
The only time that could really happen is if somebody is charged with a felony offense. The law says if they're in custody and more than 90 days have gone by without them getting indicted.
Right. And that's a due process issue, because for a felony, even though you've been arrested, you are not officially charged until you're indicted. So if you're sitting in custody for 90 days and you technically have not been charged, the DA hasn't moved forward with the case, you're sitting in there for no reason, because the DA can have years to file a charge, but it's not fair. It's not justice to let someone sit in jail indefinitely until a charge may be filed against that person.
When we talk about bail and the bail amounts, I talked about the last bail schedule that we on the district court side in Bexar County signed was in 2015. But as a result of a lawsuit in Harris County called O'Donnell, we did away with the bail schedules in 2018.
Yes, I was thinking that when you mentioned this standing order.
Yeah. And so what happened was, for folks that don't know, there was a lawsuit in Harris County that was brought out because individual judges were setting bail according to the bail schedule that existed in that county without consideration of what somebody could pay. So if somebody didn't have the ability to pay $75,000 for an aggravated type felony, then the federal court decided that that was inappropriate. Here in Bexar County, myself and the other district judges observed what was going on in Harris and other counties across the state and decided that it would be best to remove the bail schedule and leave the decision-making specifically to the magistrate judges without any sort of focus from us as what we thought they should pay attention to, because we're not the ones that are looking at those cases on a case by case every single day basis.
And that goes to what you were saying, how there's judicial independence and that no other judge can tell another judge how to act or decide. So if you're following a bail schedule, how much independence do you really have?
And in the media, in the last couple of weeks, there has been talk about magistrates and bail setting and things of that nature. We did an analysis in my office and have learned that the bail dollar amounts that have been set by magistrates for cases like murder are twice as much as what they were when we had bail schedule. For instance, the magistrates since April have been setting bail at an average of $150,000 for a murder case, where when we had the bail schedules, that was actually half of that, or $75,000. The dollar amounts that have been set by the magistrates for the other types of cases, aggravated robbery, sexual assault, aggravated sexual assault, those kinds of cases are all set average about where the bail schedules were before. So bonds have not been lowered, or bail dollar amounts have not been less than what they were when it existed before the bail schedules. However, there's this general feeling in society that somehow or another crime is rising, which is an interesting point, because we analyze and we got numbers from the San Antonio Police Department. The arrests and the actual types of crimes like murder have gone down by 37%. Homicides have gone down for the same period last year. Sexual assaults have gone down by 10% this year for the same period last year. So violent crime is actually not necessarily going up. However, there's a fear in the community that somehow or another it is. What do you attribute that to?
Public perception is a very interesting thing. And I personally love TikTok and I can spend hours on it. And it's amazing how I view my everyday life is influenced by the social media and the information I consume in my free time. So, for instance, I think people think crime is on the rise because that information is readily available to us. So you're always hearing a story. Well, I know someone who knows someone who knows someone. That's not really accurate necessarily of what's happening in the city of San Antonio. So I think part of the problem is I believe in access to information, of course, but we are flooded with information that really doesn't accurately depict or reflect what may be happening in our community. That I never question.
Well, for a lot of reasons, including the internet and access to the internet, news has become competitive, and investigative reporting has become a competitive type business.
True, because they got to keep it interesting, whether it's accurate or not.
All right, tell me a little bit about the life of Lauren Lefton. What is it? What does a day in your life look like?
I would like to use the word chaotic. Typically, my dog likes to wake me up, and so I get woken up by Paul. His breath is always bad in the morning, and Paul is a rescue dog. And so he came in as a foster, and as fate would have it, my ex-husband's name is Paul. So he comes in as a foster, and I say, oh, it's fine. I will never keep this dog because I could not have a dog with the same name as my ex-husband. And of course, I end up falling in love with this little rascal, and now I have a dog with the same name as my ex-husband. So that typically is how my day starts. Usually I have a setting either in justice of the peace or municipal courts or district or county court. So I typically make an appearance in the morning. Sometimes I then am lucky enough to have lunch with a bunch of my girlfriends. That typically does not lead to me going back to the office, or I try to be a good lawyer and go work in the office and manage my files, manage all the caseload, answer phone calls, meet with clients, review evidence. Then typically at around 10 p.m., I go to the city jail.
So is your shift over at the magistration an overnight one?
It is. I'm a night owl, apparently.
What's that like?
The thing about being there overnight is that's where most of the cases happen. So my dad always told me nothing good happens after midnight. And I would say, unfortunately, that probably is a true statement. So A lot of our DWIs happen in the evening here in Bexar County, or later hours as the bars are closing, or you've had too good of a time a little too early. Assaults kind of happen, family violence issues, even more serious crimes, serious felonies happen at night. And so really the night shift is the busy time. So typically 10 p.m. is the warm up. At about 1 or 2, you see all the DWIs start coming in. You see a lot of blood warrants coming. And then the wave really hits at about 4 a.m. And then by 6 a.m., all is quiet. But we're still working to magistrate people to get them over to the county.
When I was young, I used to watch Night Court.
Yes.
With Judge Harry.
Yes.
Anything similar to that?
Obviously, like I'm talking with you here, I do have my own personality. So it is a serious business, but you also it's okay to be a little playful, I think. So
what's the hardest thing about your job as a magistrate?
I care about people. And so really hearing the sad stories. So it's a unique perspective when people ask for help and you're not able to help them because of your role as the magistrate, or, some people have requested mental health services that I'm not able to give them. Sometimes you see people just with injuries that are not enough that they can't be in jail, but they're uncomfortable. There's limited things you can do to help people, but you hear these stories and there's a lot of sadness in our community and a lot of challenges.
Is there ever a time that you tell yourself there, but by the grace of God go I?
I say all the time, we are all one bad decision away from ending up in jail. The highest of the highs to the lowest of the lows. And I appreciate my life every day. But really, we don't think about that. But any of us could be there at any point in time. We like to think we wouldn't, but I think working in the criminal justice system, I don't know if you feel this way, we've seen how easy it is to get arrested. Even if you can be 60 years old, never committed a crime one day in your life, and then you have a bad moment, punch your wife or your husband, and next thing you know, you're in jail. Your life is forever changed, or the path you thought you were on is now different.
What are some interesting defendants that have come before you? You think of all manner of stuff. I mean, I see things in the court here. There was an individual that showed up late, clearly intoxicated. We took that particular person in. Any interesting type of defendants that you see throughout the course of your shift over at the magistration office?
Always someone interesting. I do like to check out what people are wearing because sometimes I'm wearing the same sneakers or they give me compliments on some of the clothes that I'm wearing. I do enjoy sometimes. It's a real thing when there's a full moon that people go crazy. I don't know if you're aware of that, but when there's a full moon, it gets real extra at the jail. So I think recently on the full moon we just had, a bunch of young ladies were arrested and they had been out mostly for DWIs, and there are about 5-6 of them in the cell, and they just started having a dance off. And just were having the best time twerking and just really shaking it. And so, that's always entertaining. The staff did put a stop to it. The thing is, we all have personalities. And even in a stressful situation, maybe your personality comes out even more, even less. So
away from work, what do you like to do that's fun?
So I ride horses. I own a few horses. I compete competitively on them, and I am a travel addict. This past summer, I got to go to Turkey. I'm planning a trip to Japan right now.
Wow.
So, and I'm actually going to LA this coming weekend.
That's really nice.
Yes. So I'm very fortunate. That's the best part about being a part-time judge and a full-time solo defense attorney is you get to make your own schedule.
Very nice.
So if you want to escape for a little bit, you're able to.
I never took a page out of that playbook when I had my own practice. Unfortunately, I was a little type A.
You're a hard worker. That's why. Just how you practice as a judge, I'm sure you practice as a defense attorney.
Didn't have a lot of time for myself.
Right.
That's for sure. Well, Lauren, I've enjoyed this conversation with you.
This has been great. I've really enjoyed sharing my thoughts with you, and there's deep issues here I'm glad we discussed.
Now, you are a regular listener of the podcast, is that right?
I am the #1 fan.
Excellent. Thank you for that. Do you have any last thoughts for our listeners?
Keep listening, guys. Ask your questions and let us know what topics you want to hear about.
I've enjoyed this conversation with Lauren. Thank you so much for joining us. We'll see you in 2 weeks.
You've been listening to Beyond the Gavel with Judge Ron Rangel. Join us in the next 2 weeks where we are educating the public and expanding mindsets. Head to our website, beyondthegavelpodcast.com, or your favorite podcast platform to subscribe to the latest episodes and updates.